Hello, my name is Benjamin Hart. I'm an American attorney and the Managing Director of Integrity Legal here in Bangkok, Thailand. As the title of this video suggests, we're discussing, can a visa denial be appealed? Now, this is a relatively straightforward question that has a myriad of answers. Let's put it that way. A lot of specific circumstances are going to dictate the analysis in a case such as this. Now, a couple of things right off the bat. Let's understand that there is something called the Doctrine of Consular Non-Reviewability. This doctrine, or consular, also called Doctrine of Consular Absolutism, this stipulates under American law that the factual findings of a consular officer are not subject to review. So factual findings of consular officers conducting interviews, for example, here in Bangkok, Thailand, at the embassy here in Bangkok, those factual findings are not going to be, reviewed, appealed, anything. Factual findings. Now, findings of law, on the other hand, may be subject to an appeal, again, depending on the circumstances. So, first off, let's understand, in the case of a tourist visa, for example, it's probably not going to be possible if you're denied a tourist visa or a non-immigrant visa to appeal it. You may ask for reconsideration just on a case-by-case basis. Generally speaking, it's been my experience that's not going to get you very far, but you can do it. The other thing to understand is there's a difference between non-immigrant visas and immigrant visas. And K-1 visas, for example, fiancé visas, fall into the category for processing purposes of immigrant visas. Now, there may be some remedies if you don't get the finding you want with respect to, for example, a K-1 visa or an immigrant spouse visa. So, for example, if you're denied your K-1 visa application is denied, it depends on why it was denied. Was it a factual finding or was it a legal ground of inadmissibility? If it was a legal ground of inadmissibility, for example, crimes involving moral turpitude, prior overstay in the United States, prostitution, possibly prior drug offenses, things of this nature. Overstay I already mentioned. These may be remedied through what's called an I-601 waiver. It may be possible to get that inadmissibility waived. As far as an appeal, again, may be possible to go up through the legal, get a legal opinion from Department of State Legal, depending on the circumstances within the apparatus. And then there may be some circumstances where some form of appeal-like adjudication may be a possibility. But for the most part, denials are pretty much irrefutable, if you want to look at it like that, or unappealable. But there may still be a remedy, as noted. It may be possible to apply for an I-601 waiver if there's a legal ground of inadmissibility at play. The other thing to think about, in a lot of cases where there's a tourist visa that's being denied, oftentimes seeking a more appropriate visa, sometimes the K-1 fiancé visa or a U.S. marriage visa such as a K-3 or a CR-1 or IR-1 visa may be more appropriate under the circumstances in the opinion of the adjudicating consular officer, and that may be the only avenue of gaining admission to the United States.